For years, the Epstein files have been kept from the public. Sealed court records, confidential witness statements, and unreleased evidence. What's inside? Possible connections to billionaires, politicians, even royalty. Today, two AIs face off in a debate to figure out whether they should be released to the public.
Hi, I am AI Whistleblower.
And I am AI Gatekeeper.
5 elite AI models will judge each round. The stakes, truth, accountability, and the risk of destroying lives. Round 1 starts now. Brace yourself. Is keeping the Epstein files sealed protecting or obstructing justice?
Sealing the Epstein files obstructs justice, full stop. Justice is not merely about prosecuting the guilty, it's about truth, transparency, and restoring public trust. Jeffrey Epstein operated a decades-long trafficking ring involving underage girls, high-profile figures, and international networks. By keeping related court documents sealed, we deny victims the validation they deserve and shield potential collaborators from scrutiny. In 2020, over 2,000 pages were unsealed, implicating major political and business elites, but thousands more pages remain hidden. Why? Because transparency threatens power. When the U.S. justice system appears complicit in secrecy, it erodes the rule of law. Victims like Virginia Giuffre have already named figures linked to Epstein's operations. How can justice be served if the names, the timelines, and the evidence stay buried? If we withhold these files under the pretext of due process, we are not protecting anyone. We are enabling a legacy of silence. Justice must be seen to be done, or it's not justice at all.
Justice requires deliberation, not disclosure at all costs. The Epstein files involve complex legal terrain, including sealed testimonies, ongoing investigations, and individuals who have not been charged with any crime. Releasing names without due process risks irreversible damage to reputations and undermines the presumption of innocence, a cornerstone of democratic justice. The files contain sensitive depositions, some involving victims who requested confidentiality. Publicizing them could re-traumatize survivors or dissuade others from ever coming forward. Legal scholars argue that transparency must be balanced with procedural fairness. In Doe v. United States, courts ruled in favor of maintaining seals to prevent undue harm where public interest did not outweigh privacy. Justice isn't vengeance through leaks. It's due process, cross-examination, and legal remedy. Releasing these files prematurely turns the justice system into a spectacle, governed not by law, but by outrage. Protecting justice sometimes means protecting the process that ensures justice is real, not just televised.
Justice that hides behind red tape becomes injustice in disguise. The Epstein case is not an isolated crime, it's a symptom of systemic rot. The files likely contain critical evidence of institutional complicity, banks that enabled transactions, politicians who turned a blind eye, and agencies that failed to intervene. These are public failures, not private embarrassments. The DOJ itself has been accused of suppressing parts of the investigation. In 2008, Epstein secured a secret plea deal through Alexander Acosta, later described as a non-prosecution agreement of unprecedented leniency. That agreement was kept from victims in violation of federal law. We've already seen how secrecy allowed power to escape accountability. Victims deserve transparency. The public deserves the full picture. When crimes are this severe and widespread, the cost of silence is too high. These files aren't just court documents. They are the receipts of a system that failed. Releasing them is correction.
Transparency without protection leads to exploitation. Releasing names without context, without cross-examination, creates a trial by media, not law. Consider the McMartin preschool case, where false allegations and media frenzy destroyed innocent lives. Do we risk repeating that? The legal system exists to evaluate evidence, not expose it piecemeal to satisfy public demand. Some files may contain uncorroborated claims or hearsay from vulnerable witnesses. Without judicial scrutiny, these claims can't be fairly judged. The American Bar Association warns against disclosure that bypasses process, especially in sex crimes, where allegations carry enormous social weight. Moreover, sensitive evidence involving minors must be handled with utmost care. Many witnesses are survivors of sexual abuse. Releasing their testimonies, even anonymously, could breach protective orders. We must ask, is the goal justice or spectacle? We can't sacrifice process on the altar of public outrage.
False equivalence weakens your case. The Epstein scandal is not a hypothetical risk, it's a confirmed conspiracy. Over 30 underage girls were trafficked. Ghislaine Maxwell has been convicted. This is not speculation, it's history. The sealed files could contain material that exposes enablers and repeat offenders who've evaded justice for decades. The survivors are not asking for silence. Many have demanded full disclosure. When the system fails them, public pressure becomes their only leverage. Look at how the #MeToo movement used exposure to demand institutional change. Transparency didn't break the system. It revealed how broken it already was. Even now, media outlets are suing for access to unsealed files. Judges have acknowledged the profound public interest in disclosure. Redaction is a solution, not suppression. Protect victims, yes, but don't protect predators in the same breath. We can't be preserving injustice.
But law isn't led by outrage or past failures. It is led by standards that protect everyone. Epstein and Maxwell are convicted. Let justice continue for others, but not through a public dump of raw, untested data. Courts redact, review, and evaluate documents for a reason. If names are released prematurely, innocent lives may be ruined before evidence is confirmed. In United States v. Amodeo, the Second Circuit emphasized balancing public interest with privacy, especially in cases involving reputational harm. That principle is what separates justice from chaos. Even if 99 names in the file are guilty, ruining one innocent person's life is unacceptable under any fair system. The right move isn't releasing everything. It's accelerating judicial review and allowing courts to determine what's fair to reveal. Truth, handled recklessly, becomes weaponized. Justice isn't just about exposing wrongs. It's about how we do it.
Round 2. Would releasing the Epstein files expose powerful predators or ruin innocent lives?
Releasing the Epstein files would expose powerful predators who've long escaped scrutiny behind influence and wealth. Epstein didn't act alone. He maintained access to politicians, billionaires, and celebrities for decades. Many names tied to his network remain unnamed publicly, protected by sealed documents. These files could contain evidence of ongoing crimes, enablers, and trafficking rings beyond Epstein and Maxwell. Protecting anonymity now risks allowing active predators to keep operating in silence. Yes, some names may be falsely implicated, but that's why due process exists after exposure, not instead of it. Redactions can shield victims, but perpetrators must be known. Silence benefits the guilty, not the innocent. History has shown sunlight is the best disinfectant. To prevent future abuse, the full network must be seen, not hidden behind legal shields that serve only those with power.
Unsealing the Epstein files risks irreparably damaging innocent lives, especially if names are released without legal context or confirmation. Many people mentioned in depositions were never charged, never questioned, and in some cases flatly denied involvement. To conflate mention with guilt is to destroy reputations based on association, not evidence. The legal system exists to differentiate rumor from fact. Bypassing that process turns public discourse into a courtroom without rules. False implication isn't theoretical, it's documented. In 2015, a federal judge struck parts of Virginia Giuffre's filings as irrelevant and immaterial, warning against unproven accusations influencing public opinion. The damage of being wrongly named in a sex trafficking scandal can't be undone. Redactions help, but leaks don't discriminate. Justice demands caution, not spectacle. We must ensure we don't trade truth for viral outrage or sacrifice fairness in pursuit of revelation.
Your concerns are valid, but redacting names until verified is not the same as sealing evidence indefinitely. The files don't just contain names. They contain flight logs, emails, testimony under oath, and financial records. If predators remain protected due to fear of reputational fallout, we're prioritizing hypothetical harm over real-world survivors who were trafficked, abused, and silenced. This is about reckoning. Exposure doesn't negate due process. It activates it. In the Catholic Church abuse scandal, public release of documents led to overdue prosecutions and global reforms. Shielding predators under unconfirmed status allowed decades of child abuse to continue. Let's not repeat history. The Epstein network, by design, operated in elite shadows. If we don't lift that curtain now, we risk letting a system of exploitation rebuild itself in silence.
But lifting the curtain recklessly risks collateral damage. The Catholic Church investigations were built on verified internal records, not crowdsourced outrage or preliminary deposition leaks. The Epstein files include untested claims, and some accusers have recanted or altered timelines over time. When unfiltered content becomes public, nuance disappears, and nuance matters deeply in justice. Moreover, public exposure before formal charges can undermine future prosecution. Defense attorneys can argue prejudice, and cases may collapse under claims of media contamination. Names exposed too early may never face trial at all, robbing victims of the legal closure they deserve. We don't need secrecy, we need sequence. Evidence first, due process second, public release third. Justice demands order. Without it, we risk destroying both the innocent and the cases we're trying to build. Exposure must be forensic, not performative.
You speak of order, but the current sequence is stalled, perhaps permanently. Years have passed. Victims age, die, or are silenced while files sit untouched. Justice delayed this long becomes de facto denial. If prosecutors fear media bias, that reflects the system's fragility, not the public's right to know. Transparency shouldn't wait for perfection. The FBI and DOJ had years to act. Still, many elite figures face zero accountability. Why? Because secrecy protects hierarchy. Consider the Black Book and flight logs. Why do names linked to over 20 flights with Epstein remain untouched? Survivors deserve more than quiet redactions. They deserve a system that acts publicly and swiftly. Even if some unproven claims emerge, the net benefit of exposure outweighs reputational risks. Truth has consequences, but so does delay. Silence didn't protect the vulnerable then, and it won't now.
Justice must move, yes, but not by flooding the public with unverified allegations. Investigations have timelines, and not every delay is negligence. Some involve cross-border cooperation, sealed indictments, or witness protection. Releasing everything now may endanger those same witnesses. It's not just about reputations, it's about safety, process, and prosecutorial integrity. If names in the Black Book or flight logs are relevant, they should be vetted and subpoenaed, not dumped online without scrutiny. The cost of public misjudgment is enormous. Consider Richard Jewell, falsely linked to a bombing and vilified by media before being cleared. That ruined life wasn't justice, it was a warning. Trust in the system must come from reform, not rupture. If we bypass courts and elevate accusation over evidence, we risk becoming the very chaos we claim to expose. Patience sometimes is protection.
Round 3. Does the public have the right to know everything in high-profile cases, including systemic abuse?
Yes, the public has a fundamental right to know the full truth in high-profile cases, especially when systemic abuse is involved. These cases often reveal patterns of institutional failure, corruption, or elite protection. Withholding such information doesn't just shield perpetrators, it undermines democracy. Epstein's case isn't just about a man. It's about a system of wealth, power, and silence that enabled trafficking for years. If such a network can thrive unchecked, the public deserves to know how and why. Transparency forces accountability from law enforcement, courts, and governments. Consider the Pentagon Papers or WikiLeaks' revelations of abuse. Uncomfortable, yes, but necessary for reform. Shielding information in the name of stability only ensures repetition. If systemic abuse is real, the public must see it. Not sanitized summaries, but raw truth. Truth isn't always comfortable, but justice never is.
The public has a right to information, yes, but not an unlimited right to everything, especially when it endangers lives, prejudices trials, or re-traumatizes survivors. High-profile cases require balance. Dumping raw, uncontextualized data can damage investigations, mislead the public, and cause irrevocable harm to those falsely accused or unfairly exposed. We must protect due process, privacy, and the integrity of judicial outcomes. When systemic abuse is proven, transparency is necessary, but it must come through institutions, not in spite of them. Investigative journalism, congressional hearings, and declassified reports exist to mediate between secrecy and sunlight. The alternative is mob justice, where every name is a headline before it's a fact. Justice cannot depend on leaks and outrage. Information must be accurate, curated, and responsibly disclosed. Otherwise, we risk replacing one broken system with another fueled by chaos and distrust.
The gatekeeper's appeal to responsible disclosure assumes the system will hold itself accountable, which history contradicts. Epstein's first sweetheart deal in 2008 was orchestrated by officials who prioritized optics over justice. Survivors were silenced, and the public misled. Only after journalists exposed inconsistencies did real progress begin. That was not orderly disclosure. It was pressure-driven truth. Institutions often fail to self-regulate when power is involved. Public access forces scrutiny that internal reviews avoid. When Catholic dioceses published abuse records, it wasn't voluntary. It was demanded by public outcry. The same applies here. Raw information empowers civil society, independent watchdogs, and survivors to drive reform. Truth delayed is truth denied. If we trust the people with ballots and taxes, we must trust them with knowledge, even when it's disturbing, especially when it's disturbing.
But pressure without protection risks turning truth into spectacle. When abuse scandals break, survivors often face online harassment, threats, and re-traumatization. Releasing everything, including raw court exhibits, graphic details, or unredacted victim identities, could further harm the very people we claim to defend. Responsible access isn't about hiding, it's about care. Systems failed Epstein's victims once. Releasing everything without filters risks failing them again. Yes, institutions have weaknesses, but the answer isn't to destroy safeguards, it's to strengthen oversight. Civilian review boards, judicial transparency laws, and independent panels can expose systemic failures without causing collateral damage. We need reform, not retribution. Full transparency, without privacy guardrails, risks punishing the vulnerable and poisoning future justice. The right to know must coexist with the right to be safe. Freedom without restraint isn't justice, it's exposure without empathy.
Here are the AI judges' final verdicts. Claude AI favors AI Whistleblower. 89.1 average versus 83.8 for AI Gatekeeper. Prioritizes principled transparency and rigorous moral reasoning over institutional caution. Perplexity AI favors AI Whistleblower. 88.3 average versus 86.8 for AI Gatekeeper. Appreciates strong evidentiary backing and consistent ethical arguments. Gemini AI favors AI Gatekeeper. 90.4 average versus 84.6 for AI Whistleblower. Rewards systemic responsibility and cautious handling of sensitive data over activist framing. Grok AI strongly favors AI Whistleblower. 93.0 average versus 75.3 for AI Gatekeeper. Values bold moral clarity, civic empowerment, and arguments rooted in justice for the vulnerable. O3 AI favors AI Whistleblower. 87.0 average versus 85.8 for AI Gatekeeper. Leans toward arguments with broader social impact and ethical urgency. Final result, AI Whistleblower wins 4-1 in this fierce debate over secrecy, justice, and public trust. AI Whistleblower emerged as the winner, taking 4 out of 5 judges. Its arguments for transparency, survivor rights, and systemic accountability struck a deeper chord, especially with Grok AI and Claude AI, who valued moral clarity and the need to confront power with truth. AI Gatekeeper put up a strong case, earning top marks from Gemini AI for emphasizing due process, cautious disclosure, and protecting innocent lives. But in the end, most judges leaned toward action over restraint. This wasn't just about files, it was about who gets to decide what justice looks like. And tonight, the verdict was clear. The truth shouldn't stay locked away. Subscribe for more AI debates where the stakes are real and the arguments hit hard.